Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5291, Humane Society of the United States et al. Appellants versus United States Department of Agriculture et al. Ms. Flynn for the appellants, Mr. Byron for the appellees.
Good morning.
Ms. Flynn, you're muted, I believe.
Thank you. Thank you, Your Honor. Good morning, Your Honor, and may it please the court. Caroline Flynn for the Humane Society and its members. Under the Horse Protection Act, a USDA rule has issued and becomes law once the agency has formally approved that rule and releases it to the public. Here, that point was no later than January 19th, 2017, by which time the agency had published the rule.
Welcome. I assuming you have a JA or a luck.
Uh-oh. And we're hearing sounds from other people.
I've just muted them, Judge.
Thank you. By which time the rule had been published on the department's website as a final rule and filed for public inspection. The government argues that a rule cannot
your theory, just to be clear, your theory of the case isn't limited to something special about the Horse Protection Act. You're just making a broader administrative law argument, or is yours confined to the Horse Protection Act?
Our argument is confined to the Horse Protection Act, and that's the provision we're ultimately interpreting here. The agency's authority to issue rules to carry out the Horse Protection Act, that's in 15 USC 1828. And so that's why we're focusing on the ordinary meaning of the word issue. But we believe that, background principles of administrative law about finality indicate that point has to be after the agency's reached the culmination of its decision-making process.
I'm not quite sure I understand that, because the whole point here is you're invoking an APA principle that, the way you promulgate a rule is the way you have to withdraw a rule. You went through notice and comment in and notice and comment out is your theory, and that doesn't have anything to do with the word issue, does it?
Right. Well, when the agency issues rules underneath its HPA authority, it has to comply with the APA. Mm-hmm. And we're also arguing that we know that the government's line of publication, Federal Register publication, can't be right because of the APA provision saying that unpublished rules can be enforced in some circumstances, as well as the Federal Register Act provision saying the same thing, and also saying that public inspection is when rules are valid and also when they give constructive notice to the public.
Ms. Flynn, as to that latter argument that something can be enforced against a person before publication, are you aware of any cases or any instances in which that has been applied to rules of general applicability?
Yes,
private rights?
Yes, Your Honor. We're aware of instances in which substantive legislative rules were enforced against members of the public. Often this issue comes up because the agency didn't think it was a substantive rule that needed to go through notice and comment rulemaking, or didn't think it was something that needed to be published. And the court says, well, this entity had actual notice anyway. We also have a series of cases.
What cases are you thinking about for that proposition?
Sure. So the Tierney versus National Transportation Safety Boards cited in our brief in the Fifth Circuit case. We have, in the Arlington Oil Mills versus Knievel case that we cite from the Fifth Circuit, where
Tierney was about an individual enforcement action and an adjudication of whether a pilot violated a regulation.
Right, but it was, well, maybe I might be misunderstanding your Honor's question. I think it was enforceable against all pilots and brought to bear against this particular.
But the issue there was whether that adjudication, whether the results of that adjudication had to be published in the Federal Register. The rule had been published in the Federal Register. There was a rule on the books. So that case doesn't talk about, that case doesn't, I think, support what you're suggesting it supports.
Well, I could point you to, for one, the Arlington Oil Mills versus Knievel case, where with the price differentials, where the agency issued it via a price release, and the government or this court found that that had been a rule that could be enforced against the public and couldn't be revoked after notice and comment. I think there's some other cases that are not cited in our briefs, but there's one called State of New York Department of Social Services versus Shalala. That's at 21 F3rd 485 from the Second Circuit. That was a price reimbursement scheme applicable to state, I believe, Medicare systems, where the court found that was a substantive rule that was not published that could be enforced. I think the greater principle is that if the government is arguing that the line here is Federal Register publication, the fact that some rules can be, that materials can be enforced against at least some members of the public shows that the rule must have become law. Regardless, I don't understand them to be arguing that that caveat only applies to a subset of rules or maybe non-substantive rules or rules against, a sufficiently broad segment of the public.
I think the way the statute, the APA and the FRA read, though, those actual notice cases are about a particular, I think a fair reading of them is that there are probably only about certain types of rules that are not rules of general applicability, not legislative rules of general applicability that apply to private rights. And even if that's not the case, is there any evidence in the APA or the FRA that an agency's discretion to withdraw a rule before publication? Is there anything that constrains their ability to do that?
Yes, Your Honor. We're arguing that at the point at which the agency reaches the culmination of the decision-making process, announces that its work is done, the rule has issued, and it can't be. The agency is not free to change course at that point. How
would that rule be administered in practice? How would a member of the public know what the date was? You're saying it could be posting on the website, it could be when it becomes available for public inspection. How would we know, for instance, when the date would be fixed for the purposes of judicial review? Where a statute says, you have 60 days to petition for judicial review.
Right. So I want to clarify that our argument is just about the point of no return for the agency, at which point the agency can't turn back and say, actually, our rule wasn't final and start over. So we are not putting forward a rule that would govern any judicial review statute or writ large. But at the public inspection line, that date and hour is required to be noted on the document itself under the Federal Register Act. That's in 1503 or 44 USC 1503. And as for the point of public release more generally, posting on a website, in the American Petroleum versus Cossel case, this court said that the point at which the judicial or the administrative record closes is the point at which the rule is released. So, the court must have found that to be a sufficiently administrable line for that purpose. And I'd also say that this issue, predominantly will come up during presidential transitions. And so agencies will have every incentive to carefully mark if this court decides that the line should be public release as opposed to public inspection. And to be clear, I don't think you need to resolve that issue in this particular case, given that we have both. But if it went with public release, agencies would have an incentive to make sure that date and time was known for purposes of this rule, that at that point, further notice and comment would be needed to turn back on the rule.
Ms. Flynn, let me ask you a different kind of question. As I understand your argument, your position is that these statutes, FOIA and the Federal Register Act, that they're notice statutes, right? That they tell us how agencies provide notice of a regulation they've already issued. So with respect to the latter question, that is how an agency goes about issuing a regulation, what do we look to answer that question? You cite the dictionary, but that doesn't do it for me. So I guess my question is, if you're right about your notice argument, then how do we know when an agency has actually issued a regulation and what's the standard for that? How do we decide that? What case law do we look to for that?
Our rule turns on, the
The
ordinary
word issue, right?
word issue, but also
all you cite is a dictionary.
the dictionary, but we're also, resorting to background principles of finality, which is when an agency reaches the culmination of its decision-making process. But Your Honor asked for case law. I would point you to the Public Citizen versus Mineta case from the Ninth Circuit. We cited in our reply brief.
Mhm.
In that case, the Ninth Circuit was looking at the word issue and said under, the ordinary meaning of the term, that point
The
was
Ninth
better.
Circuit relied on the dictionary, right?
It did rely on the dictionary.
Now, I'm
but-
looking for something.
Mhm.
There's nothing in the statute that you can point to that gives us any standard, is there?
Aside from the meaning of the word no, but I guess I would, to defend our line, in a more common sense way. I think when, the purpose of asking this question is when the agency can no longer turn back.
Right.
It's not about whether it's generally effective or enforceable against the general public. And I think when the agency reaches the end of its process, says, this is our final rule, announces to the world that they are done, they've made the decision, this is how they're going to defend the decision with this, preamble. That should be the point of pencils down for the agency. There shouldn't be a twilight period of, well, maybe they can rethink it, even though after that point, all that needs to happen is OFR publishes it, which is a purely ministerial act. It's not some kind of substantive review of the rule itself.
Yeah. So you and the government seem to agree that at least for the past, 3 decades or so, incoming administrations have withdrawn unpublished rules from the Office of Federal Register, and no one's objected to that. There hasn't been any litigation about that. So there seems to be a practice having developed that what happened here is okay. That what happened here seems consistent with the practice of incoming administrations, I guess, back to the Clinton administration.
It does date back to the Clinton administration, Your Honor. I would say that just because, this practice has been allowed to continue and that presidents have chosen to exercise this authority doesn't mean that this court should bless it and allow it to continue in perpetuity. I really think that this practice, does represent a very arbitrary form of agency whiplash. Like, we are here defending a rule that was the result of many, many years of deliberation. It started all the way back in 2010. There was an extended notice and comment period. They extended the comment period. They thoroughly responded to comments in the final rule that they sent out into the world as a final rule. And then that was undone after 5 minutes thought on January 20th with no explanation, no, response to any of the agency's findings where it found that this current regime, as it's, currently being carried out now, is not effective to prevent horse abuse, is not effectively carrying out the law, is rife with conflicts of interest.
Yeah. I just have one final question here for you. So suppose you win on your APA claim, that is that here the Agriculture Department could not withdraw the regulation without notice and comment. Do we need to address your other claim under the Office of Federal Register's scheduling standards? Does that even need to be addressed?
No, Your Honor. If this court were to rule in our favor on the first claim and vacate the withdrawal, we would have no basis. There'd be no basis for you to turn to the second claim. We would have all the relief we need.
So this is here on a motion to dismiss, right? Is there, I suppose the government's answer to your question, at least about the APA thing as well, there's still summary judgment. Is there, can you imagine anything the government could offer on summary judgment that would change the outcome of the APA case?
No, Your Honor, I don't think discovery is necessary on our first claim. And I think that the legal issues are straightforward. I think they're fully briefed to this point. I don't, on the first claim, I wouldn't see the need for further proceedings.
Judge Millett, did you see any questions? Yeah.
I had a couple of questions if you're
Yeah,
done.
Mhm.
So again, you talked about the word issue in the statute, but is there any daylight in your mind between the word issue in that statute and finality?
The word finality just as a matter of,
As in a final, yes, as in sort
Right.
of a final agency action, finality.
right. So we think the first prong of the Bennett v. Spear test is helpful here. The second one, whether or not the action has legal effect is sort of the question we're trying to answer in some sense. So I'm not sure that is as helpful, but I think the first prong where we're asking about the culmination of agency.
Well, let me try it again this way.
Sure.
Under your definition of issue,
Mhm.
could an agency issue a rule or regulation that still would not be final?
No.
For both prongs? No. So your understanding of issue equates with established understandings of finality.
Yes, with the caveat that, sometimes regimes have special judicial review statutes that use certain words or tie it to certain times. And so, I'm not saying that could have impact when somebody brings or asks for judicial review or brings a petition for review or something like that.
Yes. I don't mean it in that sense. I just mean the agency's done. So I understand your first prong, but the point is that it's also a rule that will have determined rights in some way or another, presumably.
Yes, it is
That's the legal right. So for those purposes of the prong, I'm not talking about when you can bring a lawsuit. I'm really just talking about it's fine. That would be final agency action in your view. Now, my other question is there any daylight in your mind between a rule being final in that way, in that legal way, and the notice and comment process being completed?
Well, we're not quibbling
Assuming
with,
it had to go through notice and comment.
Right.
I'm not talking about things that don't have to.
right. So we're not quibbling with the idea that agencies have discretion not to complete a rulemaking. So they could have taken comments and decided not to move forward at that point. But once this,
Well, that wouldn't have been a final rule either.
Exactly.
No, so what I'm asking is there can you envision a situation in which a rule that has to go through notice and comment rulemaking or is going through notice and comment rulemaking would become final before the notice and comment rulemaking process completes?
No, Your Honor.
Okay, so what is the last step? I think I understand that because your argument has to be that if they haven't finished notice and comment rulemaking, even though it's somehow final, you wouldn't be able to say that they have to withdraw it through notice and comment rulemaking. What is the last step that an agency takes that completes the notice and comment rulemaking process?
In our view, it's the release of the approved final rule to the public. But I would say that even if Your Honor disagrees with me about that and thinks that
I find this
or sorry, I didn't
a difficult area. I'm not asking it as really, I'm trying to learn from you. So,
right.
So you don't have to go to a disagree, but just explain your answer
Yes.
a little bit more. So do you mean by the agency itself releasing it, or do you read the APA and or the Federal Register Act as making public inspection or publication in the Federal Register, either public inspection in the Office of Federal Register or publication in the Federal Register, the final step, maybe a final procedural step in notice and comment rulemaking?
Our argument is the final step is releasing the approved final rule, distributing it to the public.
The agency itself, not the Office of Federal Register.
The agency itself. That said, I do, if Your Honor would indulge me, do want to emphasize that if you believe that public inspection were the better line, and that is the line that aligns with what this court said in the NAM versus NLRB case about the moment at which you test the validity of an agency's quorum. It's also the line that's more specifically set out in 1507. We went under that line as well. And there are reasons that rule is also has, things to commend it. But, I don't think that you have to decide this particular line for purposes of this case.
No, but I'm just trying to understand how it would at least be helpful to me to have a concrete sense of
yes.
Which one really is the better of those two. And your first argument is the better of those two in your view is once it's released to the public, call it a final rule. whether by the agency or the Office of Federal Register, that's the magic moment when notice and comment ends and finality attaches.
Yes, when the agency has announced to the world that its work is done, this is its decision, this is how it's defending its decision, and assuming that before that point, the prior official approval had been received from the relevant agency officials or delegates, that is the point at which we think the agency is no longer free to turn.
What do you
back.
mean by this is how the agency is defending itself?
Oh, I'm sorry. I just mean in the sense that, you know, the preamble is written to, this is what the agency is relying on. This is the kind of arguments they're making, things like that, assuming we're talking about a legislative rule. And we think that line also tracks, you know, it more closely tracks with the fact that the 552A1 says that rules can be enforced in certain circumstances when there's actual notice. That's also what the FRA says in 1507. And so since those statutes do talk about actual notice, that's why we think that, you know, that moment can precede public inspections, at least in today's age when, you know, we have website publication. But again, I would say that if the line is public inspection, we win under that standard as well.
And then, but if it's your first line, that is assuming agencies don't always do this, but maybe more commonly now in the modern day, but not when these statutes were written. If an agency does itself release to the public, post to the public, its rule, announces it as final, includes all the bells and whistles of final rule, notice and comment, rulemaking, responding to comments and everything. Could that rule be adopted consistent with Kennecott?
Yes, Your Honor. Sure. So if I could, I'd like to make a few points about Kennecott. So in Kennecott, of course, the rule had not been posted for public inspection. There's no indication the agency had publicized it at all. And when this court was approving of OFR's practice of letting agencies withdraw before public inspection, it noted that caveat on its analysis several times. On those pages of 1205 and 1206, I think it said, you know, agencies can withdraw during the confidential processing period, before public inspection, before it's made public, something like 6 times. The government focuses more on a different part of the opinion about a different claim. In that claim, the Kennecott court rejects the proposition that whenever agencies internally approve a draft version of the final regs, that's the language they use, that has to go through notice and comment. But of course, we're not arguing that internal approval without release is our line. And then if I could, I would like to point the court to one other aspect of the Kennecott decision. And this is a portion the parties haven't focused quite as much on, but it's when they are looking at a statute limitations provision for CERCLA, and they're looking at how the agency interpreted the word promulgation in the context of that CERCLA provision. And the court says that the word promulgate is ambiguous at Chevron step 1. And this was after the National Grain decision sort of setting forth that statutory interpretation default rule for the word promulgate. And the court says it's ambiguous because it could either mean Federal Register publication or it could mean the point of public inspection. We're not sure which one it is, but we think it's ambiguous at step 1. So that would be, you know, if the court had decided earlier in the opinion that Federal Register publication is, as a matter of law, the point at which a rule is promulgated, that later discussion would be odd. And we also just think that the ruling on the APA claim has to be read in the context of what came before, when the court was very clear it was only talking about circumstances when a rule is withdrawn before the point of public release.
Ms. Flynn, though, what about the language in Kennecott that, I mean, I think this seems to me at least fairly clear. I mean, it says in discarding the 1993 document, which was the rule that had been sent to the register, the agency was in no sense formulating a rule. Instead, it rejected a document that had not yet been published, nor did the agency amend or repeal a rule because the 1993 document never became a rule subject to amendment or repeal. So our court, I think, very specifically called a rule that had been sent to the Federal Register not a final rule, called it a document. And because it had not been published, it was never, it did not require notice and comment rulemaking to be withdrawn. I'm not sure how the rule that you're proposing that would turn on public inspection or possibly some point before public inspection squares with that statement and other statements in Kennecott.
Right. So I understand that those statements in the opinion are phrased more broadly, but I do think that they have to be read in the context of the court being very, very clear that it was talking about a point where the document had not been released to the public. It was still being confidentially processed. And
that was because the Office of Federal, the regulations at issue there, had a different form than they do now. So the FRA doesn't say anything about when an agency can withdraw a document from the Office of Federal Register, does it?
No, it doesn't, Your Honor. And
the reasoning in Kennecott suggested, it explained precisely that the statute was silent on that question, and that OFR's regulations were then reasonable in how they filled in those gaps. So here we now have regulations from OFR suggesting that an agency can withdraw rules before publication. Are you suggesting that regulation is unreasonable?
I think the upshot of our position is that the regulation allowing withdrawal after public inspection is unreasonable, but that hasn't been called directly into question in this case. But I also, when we're focusing on the portion of Kennecott looking at the APA claim, I would just say again that the court earlier makes clear it's rejecting an argument where when an agency internally approves a draft version of the final regulation, that needs to go through notice and comment. And that is, again, not our argument. Our argument is after the point of announcing it to the world and saying this is our final rule, that is different.
What about the cases and OFR regulations in practice suggesting that at the point of public inspection, one of the purposes of public inspection is so that members of the public or other agencies can identify any errors in the rule? And it's not uncommon for something after public inspection to be corrected or withdrawn to make corrections. What about the cases and the regulations that recognize that as the purpose of public inspection? I mean, if that is one of the purposes of public inspection, it suggests that the agency still has the ability to make changes at that point.
I apologize, Your Honor. I'm not familiar with the cases saying that after public inspection, that the public can, identify an error after public inspection, the agency can change the rule to respond to it. I'm
certainly in the OFR regulations and handbook.
In the handbook, sure. And I think assuming that, yeah. So if
you're on it right now, but yeah.
Right. So I guess I would just still say that the point of pencils down should really be, earlier when the agency has put forth its final rule. There shouldn't be a twilight zone of being able to respond to further, public response. There's always, if the public notices an error after Federal Register publication, I think the government would still say, well, at that point we can't, do anything about it unless it's a truly, completely obvious typo that can be fixed with another, Federal Register notice. But so there's always kind of a point at which the agency can't turn back. There can't be more public involvement. And I also would just be clear that the OFR processing period and all this period is not for substantive review. This is not like OMB. They're not trying to help, strengthen the reasoning or the prose or anything like that. It's really just to check for formatting things, make sure it's in the style guide for GPO. And
all the more reason, though, then it seems strange to me to constrain the agency's discretion, right? So the agency works on its rule, it's approved, it's kind of finalized internally. If they, for instance, had an internal printing press that, printed their rules, they presumably could change the rule right until the moment it was published. So I guess I'm not sure why that ability to modify something before publication changes simply because they had sent it to the Office of the Federal Register.
I would agree with you that the agency could change it before the point at which it made that rule public.
Well, so oftentimes the agency doesn't control, the agency doesn't control when it becomes available for public inspection. That's up to the OFR's internal processing, right? The OFR, once they receive the rule, they have to figure out, they have their confidential processing period, and then they make things available for public inspection when it's ready. The agency often doesn't really have any control over that time.
OFR has discretion to put a rule on a deferred schedule under if certain criteria are met. Those are the regulations that we focus on for our second claim. But the agency, the rule is supposed to be that it's supposed to be posted for public inspection 2 days after it's officially submitted by the agency. So it's not, there's not total discretion to, have it languish at the Federal Register. But I also just say, I recognize Your Honor's point that this might in some way constrain agency discretion during that period where between, public release or public inspection of the document and final Federal Register publication. I think it only matters when there's a presidential transition. Otherwise, that delta is not going to be great.
But experience that is not the case, that rules are frequently withdrawn from OFR by agencies not in presidential transitions. It is not uncommon for that to occur because the agency recognizes there's a mistake or there's something else that has to be done. So it becomes very salient at presidential transitions because obviously it's a shift in policy making, but that is not the only context in which it occurs.
Right. But we are arguing that, the agency, once the agency announces this is its rule, that is what it has said it is done. It has said this is a decision we've made. At that point, they need to stand by that decision and cannot reverse course without explaining why they are or taking comment again about why that's improper. I'd also just, I think, go back to my earlier answer that if the agency notices a mistake after Federal Register publication, they're in the same boat. So this is really just changing that point. Maybe this means that agencies have to more carefully review their rules before they make them public to make sure to catch mistakes at that point. But I'm not sure that this is going to meaningfully, imperil, the quality of agency rules.
Can I ask you a question about this public inspection at OFR? If someone, first of all, do the regulations provide a mechanism for comments from the public to be reported to OFR or the agency? Because it's a very tight time window between public inspection and publication.
Right.
Do the regulations or handbook provide a procedure for comments to be received and processed?
I'm not aware of any regulation. And as Your Honor said, the time frame is supposed to be very tight.
And the handbook?
I'm not sure of anything in the handbook. I'm
Okay.
less
And would comments
familiar
go,
about parts of that, but yeah.
would comments go to OFR or would they go to the agency?
Well, sorry, I should say I have no reason to think that there is any mechanism for comments. I just, I'm not as familiar with every part of the handbook, so I just didn't want to completely rule out the possibility, but I have no reason to think there is such a mechanism, so I don't know where they would go.
And agencies don't have a mechanism for, or maybe they do. Are you? I can ask the government this too. Maybe I shouldn't ask you, but is there a mechanism at that point for even the agency to receive comments based on the public inspection done at OFR?
Not that I'm aware of, Your Honor.
Okay, thank you.
And, I think that, well, I'm sorry, I see that my time is.
No, you can go ahead.
Thank you. Public inspection, it's set out in 44 USC 1503. I think as the Federal Register explains it, it seems to be sort of the official stage of public release. 1507 talks about that being the point when the public has constructive notice. There are, things that follow from it in terms of enforcement capabilities, but it does, the fact that the date and time of public release is supposed to be noted on the document suggests that the FRA considers that to be sort of the legally significant point at which the public sees the document. It's been, the agency's work is sort of being publicly aired.
What's the point of that date? Does that show up at some point as part of the regulations publication date? Or is it, the publication date is the next,
Yes.
the way the schedule sets it out. So maybe generally the next day after public inspection. So what is the point of that date? Just it starts the clock running at OFR?
It's noted on the document itself, the original in the National Archives. I think it is, just considered to be a legally significant stage. 1507 says when the rule is actually published, that creates a rebuttable presumption that it was posted for public inspection the way it was required to. So I understand that in this day and age, people, when you look at the Federal Register, you look at the publication date, but the Federal Register Act itself sets out public inspection as its own legally significant stage.
Okay. Thank you. Unless my colleagues have any further questions, we'll hear from the government.
Thank you, Your Honor.
Morning, Your Honor. May it please the court. Thomas Byron from the Department of Justice, here for the federal government, the defendants in this case. I'd like to emphasize at the outset that there are two distinct claims in this case, or two sets of claims, one under the APA involving the question that we believe is controlled by Kennecott and other cases, and that's whether withdrawal of a document from the Office of the Federal Register before publication is a rule requiring notice and comment or reasoned explanation under the APA. We think, again, Kennecott, as well as cases like Chen and Zhang, make clear that it's not such a rule and no procedural requirements are imposed by the APA. The second claim that the plaintiffs—
What do you do with Ms. Flynn's argument that Kennecott is different because there was no filing and making available in the office? It was not made available for public inspection in the Office of the Federal Register. So it just didn't deal with that question.
Judge Tatel, I think you're exactly right that the Kennecott decision didn't deal with that question because it wasn't presented in that case. Nothing in the case indicates, as the district court here correctly recognized, nothing in the court's opinion in that case, as I think Your Honor may recall, indicates that any different outcome would be required under the APA. And again, this is why I want to distinguish.
But isn't that, I mean, it's an interesting question about how one interprets a precedent of a court, right? I mean, the other way to look at that is the Kennecott court decided a case based on a set of facts. And the question about whether that precedent binds a court in a later case with different facts, we don't, it depends on what the latter court says. There's no reason to expect that the original court would have said, oh, by the way, this principle applies even in situations where it's made available for public inspection by the Office of the Federal Register. I mean, I'm not sure that's the way we interpret precedent.
My apologies, Judge Tatel, I didn't mean to suggest otherwise. If I could make
you don't need to apologize. It's an interesting issue, actually.
I absolutely agree. And I want to make 2 points about the public inspection aspect of the plaintiff's argument here. So one of them is that in the Chen and Zhang decisions in the Second and Ninth and Second Circuits, contemporaneous with the Kennecott decision, also dealt with the withdrawal of a document from the Office of Federal Register that otherwise would have created a rule when it was published. And in those cases, both courts held that even though the document had been made available for public inspection, and that's the very distinction the plaintiffs here rely on, even though in that case, the 1993 AG regulation about asylum had been made available for public inspection, it was withdrawn and never took effect. And that's important, we believe, because it informs the proper understanding, not just of Kennecott itself, but of the principles Kennecott applied. And with respect to the APA claim, a document that's withdrawn before publication in the Federal Register is not a rule. It does not create binding obligations, and the withdrawal of such a document does not require notice and comment.
And what do you do with the Federal Register Act itself, which says that a document required to be published is not valid against a person who has not had actual notice until the duplicate original is filed and a copy made available for public inspection. So that statute says that once the regulation is made available for public inspection by the Office of Federal Register, it's valid and enforceable, at least against people with knowledge, right?
Yes, Judge Tatel, and in fact, I think in
you don't disagree with that, right?
Absolutely right. So
then just explain to me how a rule that becomes valid and enforceable as a result of notice and comment rulemaking can be withdrawn without notice and comment rulemaking.
Absolutely, Judge Tatel. And I want to make clear that the situation you described and the situation described in that provision of the Federal Register Act is not what we're dealing with here. The pre-publication enforcement of a rule can only take place when a rule is immediately effective, that is, effective before publication. Those are very rare instances, as the APA Section 553D makes clear, because ordinarily the effective date of a rule is triggered by publication or service of that rule, and it must be at least 30 days after publication or service. The scenario that you're describing that plaintiffs put so much weight on, that, for example, the Ahrens case in the Second Circuit from, I think it's 1962, reflects, is where there's an urgent need for immediate enforcement before publication. And the agency makes that clear, and the rule is effective before that time. This rule was not to be effective immediately, was not.
But can I hang on and ask you, so as to a rule that, say, is immediately effective in the way that you've described, and let's say it was promulgated through notice and comment rulemaking, your position, I take it, is that rule, once it's enforceable against an individual, is final, correct?
Judge Millett,
and it's final in the sense that, let me be crystal clear here, final in the sense that if you wanted to change, even though it has not yet been published, if you wanted to withdraw it, you would have to go through notice and comment rulemaking.
Judge Millett, I want to quibble with the hypothetical, if I may, in one respect, and that is that, remember, the 553D requirement for a shorter effective date, including a pre-publication effective date, it can be, it requires a good cause determination. And
sure,
that might also equate to a similar good cause determination that notice and comment is not required. I think, we don't know. We don't have a lot of examples of this, in fact, because it so rarely arises.
that's fine, but I'm asking you about my hypothetical.
Sure.
Okay?
So in a scenario where there is notice and comment rulemaking and an agency
To
determines—
be expedited notice and comment rulemaking.
Sure. And, I think the FCC case that is discussed in the briefs, and I apologize, I'll think of the name of it in just a moment. It may be an example of this, where there was very expedited notice and comment available. Mm-hmm. That was one of the issues addressed. So in that scenario, to the extent that the rule had been immediately effective, enforced with respect to those who had actual notice, because that's another aspect of the requirement, certainly we think that the rule was effective and did bind those parties with actual notice, the Federal Register.
No, that's not my question. My question is whether it bound the agency in the sense that it could only then withdraw that rule, even though it had not yet been published, by going through notice and comment rulemaking.
Judge Millett, I think, and I want to be cautious here because I'm not aware of any case law that addresses that question. I think the answer would probably be yes, but again, a lot might depend on the circumstances of the particular.
Well, I don't understand. So under that hypothetical, notice and comment rulemaking has been completed, albeit expedited, but it's completed. That's done. You've issued a rule through notice and comment rulemaking. It is a final rule.
Yes.
It is a rule of law being applied to people with actual notice.
Yes.
And yet you say it's unclear whether if you wanted to withdraw that rule, you would have to go through notice and comment rulemaking. Is that the answer you just gave me?
Judge Millett, the answer I just gave you is I'm not aware of any case law addressing this.
So the answer, if it's unsettled, the government thinks is not a clear answer to that.
Judge Millett, I think there's not clear case law. I believe the answer is that the requirements of the APA would be required, would need to be followed in the hypothetical you give. Now, again, there may be good cause to forego notice and comment for withdrawal. Right?
There could be, or maybe that would be expedited too. But I don't want to talk about good cause exceptions here. But what I want to talk about, I mean, that may be an answer to another question. But to be clear, then a rule can become final, enforceable, and I know enforceable suggests effective dates, but that's necessarily true for pre-enforcement like this. Prior to publication in the Federal Register. Federal Register allows you then to enforce it against the world, even if they didn't have actual notice. That's all the Federal Register publication would accomplish at that point in my hypothetical.
Judge Millett, I think that's right in the sense of, in the example of, as in your hypothetical, a rule that is immediately effective. Right. And that's a key distinction, I believe, Your Honor.
Well, let me just ask you about that, because immediately effective. Well, first of all, the Act doesn't say that. The Federal Register Act does not say that only regulations that are only regulations that are immediately effective are valid once made public by the Office of Federal Register. It doesn't say that. The other point is that, so let's assume you're right that the effective date is critical and that a published regulation, it gets published in the Federal Register and it's not effective for 30 days. Is your point that that could be changed up until the 30-day point?
No, Judge Tatel.
Well, then I don't understand. Effective date you can't have it both ways. In other words, if you're right that that under the Federal Register Act, the only regulations that are valid and enforceable are those that were made by the agency to be immediately effective, then it must be that even once a regulation is published, it's not valid and enforceable until its effective date.
Judge Tatel, I think if I may step back for just a moment and again return to one of your earlier questions, which was about the Federal Register Act's provision.
That's what I was just talking about.
Yeah, so again, I think I want to distinguish between the APA question and the FRA claim, the Federal Register Act claim. I think the two are distinct and it's important to separate them. So the plaintiffs here say that under the APA's rulemaking requirements, as Judge Millett was asking about, apply whenever a document is withdrawn after it's been released by the agency or filed.
Why don't we assume for purposes of our discussion here, at least for my benefit, that I'm not sure I agree with them, but that I do think that the significant date is the Office of Federal Register making it public. Let's focus on that.
Sure. And
okay.
So with respect to the Federal Register Act claim, Judge Tatel, I think that's right. And then the question becomes, can the plaintiffs compel publication on a particular date? Because that's the basis of the claim they make under the Federal Register Act. They say
but we don't have to get to that if we think they're right on their APA claim, right?
I think that's right, Judge Tatel.
You agree with that, right? So if the agency here could not legally have withdrawn the regulation, then we don't have to get to the Federal Register. The rules, the Federal Register timing claim, their second claim, correct?
Right, Judge Tatel.
Okay,
and
so why don't we stick with the first claim here?
So under the first claim, public inspection is not a meaningful marker with respect to the documented issue in this case. And again, I want to emphasize the difference, as I did with in response to Judge Millett's questions, between an example like Aaron's, where the document was immediately effective and actually was never published, if I understand the court's opinion in that case correctly. And in this case, where a document is not to become effective until after publication. Publication is itself then the meaningful marker, as this court held in Kennecott, in this scenario.
Well, we're going in, I'll ask my question once more, and then we'll just agree to disagree. But I don't see where you get that in the Federal Register Act. It doesn't say that. It says it's valid and enforceable once it's made available for public inspection. It doesn't say anything about it having had to be made effective by the agency. That's not what it says.
Understood, Judge Tatel. And again, I think this goes to the distinction between the plaintiff's APA claim and their Federal Register Act claim. So nothing in the APA requires that a rule be enforceable before its effective date. And so I think the fact that some rules can be effective in the rare instances before publication doesn't necessarily compel the conclusion that plaintiffs urge here, which is that every rule must be effective before publication. That's contrary to what Kennecott held. It's contrary to what Chen and Zhang held, particularly with respect to rules already made available for public inspection by the Office of Federal Register.
Mr. Byron, could the government, the provisions in the APA and the FRA that speak about enforcement upon actual notice, do you think the government could enforce a regulation that required notice and comment rulemaking that was a substantive rule? Do you think the government could enforce such a regulation against a person before its effective date?
Before its effective date, Judge Rao, no. I think the answer is pretty clearly no. And that goes exactly to the point I was trying to make a moment ago.
And do you think such a rule can become effective without publication in the Federal Register? So there are some types of, let's call them regulatory documents, like they're like in errands or some of these other cases. Do you think a rule of general applicability that affects private rights could become effective without publication?
Judge Rao, I don't know the answer to that. I think it's possible, but again, it's so rare that an agency even seeks to make a rule effective immediately prior to publication that we don't have a lot of examples of it. In fact, many of the examples that we have are before the 1966 amendments to the APA, and Aaron's is a good example. The FCC case that we were talking about a moment ago is another good example. And the FCC case in particular was a change in agency regulations. It was a freeze on filing of applications for radio.
Wasn't that a procedural rule in the Kessler case that didn't require notice and comment rulemaking in any event?
I think that's probably right, Judge Rao. Again, I'm not aware of any examples of the kind of rules your hypothetical contemplates, and so I can't think of any. But at the same time, I do think that it's fair to say that nothing in the text of the Federal Register Act would necessarily preclude an agency in an instance where good cause, where it could find good cause for an immediate effective date, to seek to enforce a rule before publication, even if that rule is one of general applicability.
What about the Congressional Review Act? Does that tell us anything about when the agency's rulemaking process becomes final? Because the Congressional Review Act says that a rule cannot become effective until the later, a major rule cannot become effective until the later of 60 days. 60 days that passes either from sending the major rule to Congress or publication in the Federal Register.
I don't think
does that tell us anything about the question at issue here?
I don't think it necessarily does, Judge Rao, but I do think it's consistent with the emphasis that I've tried to point out about the importance of the effective date. In other words, in most situations, all but the rare scenarios for where pre-publication enforcement based on actual notice is appropriate, in most situations, a rule will not be a rule if it's not published. And that's what this court held in Kennecott. That's what Chen and Zhang held. That's consistent with the case law here. The fact that in some rare scenarios, other rules have been held to be immediately enforceable, therefore valid with respect to those who have actual notice, doesn't undermine that conclusion. And I think the example of the Congressional Review Act merely bolsters that conclusion.
I'm just getting really a bit confused. Do you equate effective, when a rule is effective, with when it's final, in the sense that the agency is done with it?
No, Judge Millett.
No.
Those are very different questions.
Right. And okay. And then do you equate effective with the completion of notice and comment rulemaking?
No, Judge Millett.
No. And so the question, as I understand it, is whether the agency had finished its notice and comment rulemaking process and had issued a final rule, even if its effective date, whether it's immediate upon issuance or whether it's 30 days later or 60 days later. Because once they have a final rule that has completed notice and comment rulemaking process, it can only be withdrawn by that agency through notice and comment rulemaking. So I don't see, and I think that's what was embedded in your answer to Judge Tatel, that because otherwise they could withdraw it after publication in the Federal Register because the general rule is 30 days there. So I don't understand why we're talking about effective. The reason I was asking about pre-enforcement is that suggests it's a real rule, a final rule, a completed rule, and that can happen before Federal Register publication. So I don't understand your emphasis on effective.
Let me see if I can come at this a slightly different way, Judge Millett, to address your question. And I apologize if I have been unable to.
I'm sure it's my end. I'm sure it's operator error on my end.
I doubt it. I don't want to overemphasize the importance of effective date. The point I want to make is that this court's decision in Kennecott, consistent with Chen, Zhang, many other decisions, is that a rule is not a rule until it's published in the Federal Register. That's the ordinary.
No, that's not what Kennecott held, was that a rule can be withdrawn without notice and comment consequences prior to public release. That's not, which is not the same thing as publication. Right there, it had not been disclosed to the public by at least according to the briefs in the case, had not been disclosed to the public at all. It wasn't as though the agency had disclosed it on its own. It hadn't been released for public inspection. And some of the rationale in Kennecott is like, nobody's laid eyes on this outside the agency. You can't be done until that's sort of the way of being done, is when the agency says, we're done, here it is. I mean, that's part of notice and comment rulemaking, is that you explain to the public your final, you don't just issue a final decision, you explain it to the public. And so you can't even have the end of notice and comment rulemaking without a public explanation of what your final answer is.
Judge Millett, may I just point to a particular passage in Kennecott at page 1208 of 88 F. 3rd, which says that the 1993 document, quote, never became a binding rule requiring repeal or modification. I think that's significant. Again, this is with respect.
Right, because it had never seen the light of day outside the government itself, right?
I think that's not the only reason, Judge Millett. If that were the
wait. Okay, I'm sorry. Finish your sentence.
So if that were the case, Chen and Zhang would have had to come out differently. In other words, this court would now have to, in order to reach a different conclusion based solely on the fact of public inspection, would have to disagree with the Second and Ninth Circuit.
You mean based solely on the statute?
I'm sorry, Judge Tatel?
I said. You mean based solely on the statute?
I'm not sure I understand the question.
You said if we were to reach a different result based solely on publication, I think that's what you said, right?
No, Your Honor. I'm sorry.
Publication, making it available to the public.
For public inspection.
Public inspection.
That's right.
Yes, you're right. And my only response to that was, well, that's what the Federal Register Act says. But let me ask you this, since we're talking about Kennecott. Suppose this panel, this is a hypothetical, suppose this panel does not interpret Kennecott the way you do, and suppose we do not think it resolves this case. Can you still prevail?
Yes, absolutely, Judge Tatel.
What's your argument without Kennecott?
Well, it's principally, as I emphasized, that Kennecott doesn't stand alone. Chen and Zhang decided contemporaneously also reflect that a document can be withdrawn after public inspection.
But were they grappling with this APA question there?
I think they were, Judge Millett, in the sense that the question was whether the document in that case, the 1993 document that was an AGRI, an Attorney General regulation about asylum, could be applied to the claimant, to the asylum claimant in those cases. And I guess.
Did they say it had been permissibly or impermissibly withdrawn?
Well, no, Your Honor, they said it had never become effective because the effective date was based on publication. And indeed, in that case, it was intended to become effective.
Right, so that ruling was based on their view of whether that rule had become effective, but they didn't address this question about whether something could be withdrawn and what the consequences of that would be. I mean, as we all know, there's a lot of words here that have different roles in this process and get used sometimes interchangeably when perhaps they shouldn't. I'm sure I've made that mistake many times myself, but I just don't, one, those are not circuit precedent here, but two, I don't think there's any conflict because they just simply weren't answering the same question. I get that there's some, you might argue that there's some sort of atmospherical relevance to it, but they simply weren't answering the question that we're asked here, were they?
Judge Millett, I think it's fair to say that they weren't addressing the very specific question whether notice and comment was required or whether a reasoned decision was required to withdraw.
Or whether the withdrawal itself is permissible?
Judge Millett, I think they necessarily had to answer that question. In other words, if the rule was not permissibly withdrawn, it would have.
Well, I mean, did they have to answer in the sense, was that argued to them?
I don't know that it was argued. It wasn't specifically addressed in the
so that's what I'm saying. It's not in the opinion.
Right.
So I guess we'd have to look at the brief to see if it was even raised in that case. If it weren't raised in that case, then we really know they weren't confronting this question.
Well, one thing, if I may emphasize here, I want to distinguish between the APA argument and the APA claims and the FRA claims. And I see I'm over my time. If you'll indulge me for just
you go ahead, because I have another question too. So go ahead.
Thank you, Your Honor. I want to distinguish between those claims because, again, in the Kennecott case itself, the court distinguished between those two types of claims, and it addressed the APA claim with respect to whether the withdrawal of the document required notice and comment or reasoned decision making. It addressed separately the FRA claim, and in addressing the FRA claim, the court asked the question whether the Office of the Federal Register's regulations were permissible interpretations of the Federal Register Act, the statute itself. And I think that's the appropriate question to ask here with respect to the meaning of the Federal Register Act, to the extent the court's relying on that. And here, the regulations of the Office of the Federal Register include a specific reference to withdrawal of a document after public inspection. I believe that's in, I apologize, I'll need to pull the site, but I think it's 5.17. In that it permits the withdrawal even after public inspection. So the question about the Federal Register Act that has been informing some of the court's questions, I believe, should I think be understood in light of the Office of the Federal Register's interpretation of that.
When Kennecott, we didn't hold that every single thing in every Federal Register regulation was permissible. We were addressing the application for public inspection because the statute itself is, I think Judge Tatel pointed out, the statute itself gives legal consequence to public inspection. And so an agency regulation could not certainly countermand the plain text of the statute in that way.
Absolutely, Judge Millett. I didn't mean to.
It was an ambiguity, right?
I do think
so they didn't confront that.
The analytical framework that the court undertook with respect to those regulations is appropriate here as well in terms of understanding the Federal Register Act. Right. And there was a question during my opposing counsel's argument about whether the regulations at the time of Kennecott also permitted withdrawal of a document after public inspection. I don't have those earlier regulations here, but I'd be happy to find them and cite them for the court and and address that question directly, because again, that question just wasn't addressed in Kennecott. So with respect to the APA claim, Your Honor, I do want to emphasize the impracticability of plaintiff's argument and the grave uncertainty that it would introduce. The idea that a rule becomes a rule, valid, requiring the ordinary notice, comment, reason, decision-making to make any changes, and presumably effective on all who have actual notice when it's made public by the agency, or even with respect to everyone after it's posted for public inspection by the Office of Federal Register, that would create enormous uncertainty.
Why would the latter create enormous uncertainty?
Because
any more than publication. Publication in the Federal Register, I mean, it comes out online. It's published digitally. Sure, it comes out on paper also, but in terms of the notice to the public, I'm not sure what the difference is between the Office of Federal Register putting it on its website and it 4 days later appearing on the digital version of the Federal Register.
Just the reason. Oh, sorry, Your Honor.
No, that's all. What's the difference?
I think that the reason it would create uncertainty is that over the last 30 years, there have been multiple instances. Chen and Zhang is one. We cited at least 2 other documents that were withdrawn at public inspection in 2017. There are at least 2 more that I'm aware of in 2021 that we cited in our brief as well, that were withdrawn after public inspection. So the uncertainty goes to what is the ongoing effect.
They weren't challenged. They weren't challenged, though, were they?
That's right, Judge Tatel.
Yeah, okay.
Although, as I pointed out in Chen and Zhang, several
Let
individuals sought to rely on them.
Mr. Brennan, let me just ask you a different question about your view here. Is that your basic view, the government's basic view, is that the key here is Federal Register publication, that sets a key date. So I want to ask you about a different provision of the Federal Register Act, which it has a special filing provision in it. And it's here, I'll just read it to you. For when a regulation, quote, is issued, prescribed, or promulgated outside of the District of Columbia, issued, prescribed, or promulgated outside the District of Columbia. So my question is, how could a regulation be issued, prescribed, or promulgated outside the District of Columbia if, as you say, publication in the Federal Register is what's critical?
Judge Tatel, I think the fact, I think you're absolutely right. And the premise of your question, I think, is that a rule can be issued, prescribed, or promulgated without publication in the Federal Register or prior to publication in the Federal Register. I think the Federal Register Act also supports that, at least arguably, in 44 USC 1507.
Yeah, but then if a regulation, let's just cut to the chase. If a regulation is issued, prescribed, or promulgated, your theory is it can nonetheless be withdrawn without notice and comment rulemaking, right?
Before publication, yes, Your Honor.
Okay, I understand your position. Unless Judge Rao or Judge Millett have any other questions.
So can I ask one more?
Yeah, go ahead.
And that is the question I was asking your friend on the other side about, and that is this, oddly named public inspection process. Is there anything either in OFR regulations that we didn't see, or handbook, or agency regulations or practice that provides a mechanism for public comment as part of that public inspection?
No, Judge Millett, but there is a mechanism in the OFR regulations that provides for agency and OFR exchange of information about errors in the document, and that includes a basis for withdrawal of the document even after public inspection. And that is, I believe, in 1 CFR 18.13, if I can take a moment to find it. A document that's been filed for public inspection but not yet published may be withdrawn from publication or corrected by the submitting agency. And it also says extensive corrections may require agency withdrawal of the document from publication. So I think that reflects that this is not necessarily, none of these regulations nor the handbook are about the public's involvement. They are, as we explained in our brief, about the interchange of information and the efficient operation of the exchange of information between OFR and the rulemaking agency. I want to emphasize—
And just filed, just to make sure I've got all these words right, filed for public inspection means filed by the Federal Register notice, or is that when the agency files it with OFR and it gets its date stamp and stuff?
No, Your Honor. So let me take a moment, if I may, to address both the statutory and the regulatory framework here, because I think the plaintiffs have misunderstood some key aspects of how OFR operates. And again, this is understandable because OFR's procedures are designed to ensure smooth operation with respect to the office and the rulemaking agencies, not with respect to enforcement by plaintiffs. So 44 USC 1503 talks about filing documents. And this is, again, after the confidential processing period, which ordinarily includes extensive editing, review, exchanges of information between the office and the rulemaking agency.
Wait, 1503 is talking about after it's already been submitted?
Yes.
I thought that was talking about when it was original and two duplicates are given to OFR, shall be filed with the Office of Federal Register.
Your Honor,
and then this confidential period happens.
Well, Your Honor, the statute's not entirely clear about this, and that's why the regulations and the handbook are important in understanding how OFR actually operates. And so I'll turn then to the
Wait, so you read 1503. I'm really confused here. I had thought that because this is the provision, isn't this provision that talk about I thought this was the trigger when it got its sort of time and date stamp.
Yes, Your Honor, and that's
okay, and that's at the end of the confidential period here.
Yes, Your Honor, and I think that's what led to some of the confusion in plaintiff's argument. So if I can just address this, I'll explain a little bit further. I apologize for the length of time it takes to explain this. So looking at the OFR regulations, which are again in our addendum at page 7 and subsequent pages, the receipt and processing talks about the receipt of the document by the Office of Federal Register when it's sent from the rulemaking agency. That begins the confidential processing period, includes extensive review, editing, corrections back and forth with the agency, et cetera. There's that confidential processing period also ordinarily includes extensive formatting, working with the daily volume office of the Federal Register to ensure that there will be room in the particular volume of the day that's going to be selected.
Yeah, that's just all logistical stuff. I mean, I'm sure it takes time and effort, but it's pretty time and effort. But it's not substantive.
Well, Judge Millett, no, I don't. I think you're right.
Is the OFR reading this thing to say, I don't think this makes substantive sense?
Judge Millett,
are they providing substantive comments, or are they going, you've misspelled?
There are some substantive requirements that the office imposes with respect to its rules, but it doesn't impose
on the substance of the federal rule itself?
Not the policy judgment of the rulemaking agency. No, Your Honor.
What kind of substance does OFR enforce?
Well, there are certain requirements in the agency's rules and in the handbooks, both the document draft.
Can you give me an example that's substantive? What you're defining as substantive?
Well, I don't want, Your Honor, I don't want to overstate the point about substantive. There are things that this is not just typo correction.
You can understate it by just giving me an example.
I don't have an example ready at hand, Judge Millett. I apologize for not having that.
Okay. Anything else?
I can just follow up. Go ahead.
I just wanted to go ahead, Your Honor. I apologize.
You need to finish. I'm sorry. Go ahead.
I just wanted to finish the answer about the process point with respect to the regulations. So the receipt and processing takes place, but the public inspection and the timing of the filing, which takes place after that, is the filing and public inspection only takes place after the publication date has been assigned. So that's one of the fundamental misunderstandings that plaintiffs have about the way this works.
What does that have to do with the issue before us?
Your Honor, I think it has to do principally with the Federal Register Act claim, but it also has to do with the question.
Wait, but why? Why? What difference does it make whether the agency sets the publication date before or after that 2-day period for purposes of the case before us?
Because in the Federal Register Act claim, the plaintiffs seek to compel, they argue that the Office of the Federal Register was required by its regulations as a mandatory matter enforceable by 7061 under mandamus standards, required to publish on the 23rd, not the 24th of January.
But you've agreed that didn't you agree in the district court that they're right about that?
No, Your Honor, we did not. And the district court did not so find. That's a key, that's a really important part of the argument here. The plaintiffs are seeking to compel publication under the Federal Register Act in their separate OFR claim against OFR, based on their theory that the regulations required publication on a particular date. That's not correct, Your Honor.
Just ask one practical question. If this
Judge Millett, do you have anything else?
Oh, I had one.
Judge Rao, go ahead.
Yes, I just had one quick question. If this court were to rule that that the point at which a rule becomes final and cannot be withdrawn without notice and comment rulemaking was public inspection, does the government have a view of how many other rules that were withdrawn using that method? Would those other rules also then be in effect based on the reasoning of this court's opinion if we were to set such a line? And does the government have any idea of how many such rules would effectively spring into effect from the past, I don't know, 10, 20, 30 years?
Judge Rao, we haven't canvassed that far back. I noted in an answer to Judge Tatel's question that our brief identifies at least 2 other documents in 1997 and at least 2 documents in 2021 that were withdrawn after public inspection, and that Chen and Zhang referred to one in 1993. Undoubtedly, there are more. I think it's hard to know. We could certainly conduct an extensive survey to determine that, but I think the uncertainty is what I wanted to emphasize.
Would your view be that those rules would then have to be published under the reasoning, like if we were to set the rule that the Humane Society is requesting here?
Not necessarily, Judge Rao. I think it would depend on whether Judge Tatel asked the question whether anybody had challenged those. And I think that might be relevant. I think the statute of limitations might be relevant to particular circumstances. It would, of course, depend as well on the reasoning and conclusion of any decision this court might reach. I would urge the court.
Right, so just to be clear, right, the statute of limitations on the 1970 whatever rules is going to long since have run for any APA claim.
I'm sorry, Judge Millett, I'm not sure what you mean by 1970s.
You mentioned that I think is this in Chang, the 1970s?
1993, Your Honor.
1993. I'm sorry, I thought you said something from the 1970s.
No,
okay,
Your Honor.
Regardless,
1993, 1997, and
right.
21 were the examples I gave.
Right. So 93 and 97, I assume the government's position would be this. Thank you very much. The statute of limitations is running.
We'd need to analyze that if a claim were brought, Your Honor.
Oh, you're not.
Okay.
Okay.
All right. I think we have exhausted the subject.
Thank you, Your Honor.
Yeah.
We'd urge the court to affirm. Thank you.
Let's see, Ms. Flynn, you used up all your time, but you can have 3 minutes.
Thank you, Your Honor.
And I'm sure you have a lot to say, but could you start with this point the government's making about effective date?
Yes, Your Honor. So, as I understand the government's presentation today, they're saying that the rule is either publication or it's when the rule is effective date, or so when the rule is effective because its effective date is passed. And I guess each of those lines have their own problems, and combining them, I don't think solves them. So publication, we've already talked about. The statutes at issue make it clear that at least some unpublished rules can be enforced. An effective date, there's a line of precedent from this court and other courts saying that even if a rule's effective date has not yet come to pass, the agency can't postpone it without notice and comment. So we know that the effectiveness of the operation of a rule does not determine whether or not it's law. That's the same way it works for statutes, for instance, that have delayed effective dates. If I could move on to a couple of points that,
sure.
We talked about the potential disruption caused by a decision here. You know, as the government said, they did not attempt to sort of put a number on that for this court. We tried to look into it ourselves. For instance, the rules that the government cites in their brief that were also withdrawn at the same time, one of them actually was published anyway. So that one, there's no problem. The other one they point to from that same transition, a substantive rule, that same name, was actually fully published before the transition. This document, it's not clear what it would have done, but that rule eventually went into effect after some postponement. So I'm not sure we can see a problem there. Overall, we were only able to identify at most 15 rules that were withdrawn after public inspection. For about half of those, they were just published anyway. Some of them were subject to legislative fixes, like the rule in Chen and Zong, where Congress actually stepped in. Other times, the rule basically went into effect after notice and comment. So at the end of the day, we only identified one rule that is completely similarly situated to ours. You know, it was withdrawn after public inspection, that, you know, potentially a decision in this case could implicate. But we'd also say that, you know, this decision is about the Horse Protection Act and the rule making authority there.
What was that date? What was the date that the other one was withdrawn?
I believe it was the latest transition, Your Honor.
The 21 one. Okay.
Yes.
Ms. Flynn, in the cases where, in the instances you say where a rule was withdrawn but then published anyway, do you mean that it was withdrawn but then sent back to the Federal Register and then published?
I'm not sure of the mechanisms, but my understanding is that the rule that was sent was published. Like the agency followed through with it after, you know, the new administration allowed it to happen, rather, you know, as opposed to withdrawing it entirely or going through notice and comment again or replacing it with a different rule. The government.
Right, so the published rule was identical to the one that had been, so they sort of pulled it back and said, oh, never mind, and then let it go forward to publication or resubmitted it for publication or something.
Yes, Your Honor, or at least substantially identical. So the government mentioned, of course, the Chen and Zong decisions. You know, I first would point out that a ruling against us in this case would create a split with the Fifth Circuit in the Arlington Oil Mills versus Knievel case, where the Fifth Circuit ruled that a rule announced in a press release could not be overtaken without another round of notice and comment. As Your Honor, as Judge Millett pointed out, I think Chen and Zong were addressing a different issue. Those were habeas claims. The court was trying to figure out whether it could enforce that withdrawn rule in those immigrants' cases. It was not looking at the type of APA claim we have here. And I think the Second Circuit's analysis in particular, which is, you know, sort of the lengthier decision on this topic as compared to the Ninth's, the court does recognize that sometimes unpublished rules can be enforced. They acknowledge that outside of their discussion, but they've hinged their ruling on a far more narrower point, which was that the rule there had a placeholder effective date that was hinged on Federal Register publication. We don't think that's correct, but it's a much narrower ruling than what the government's asking for here, which is that any rule that is not published cannot take effect and it is invalid. I'd also just clarify that our position is not that all rules after the point at which the agency finishes its decision-making process and releases the rule, we're not arguing that they're immediately effective at that point. The effective date still governs for substantive rules with delayed effective dates. It's just that at that point, the agency can't turn back. We're not arguing they're generally enforceable against the public at that point. And then Judge Rao, you brought up the Congressional Review Act. And I think that's helpful in that it illustrates that the government's logic would spread much more broadly. So, you know, if the government's arguing that because normally substantive rules can't go into effect until 30 days after publication, it must mean Federal Register publication is a necessary condition for validity, then I think the same would have to carry over to the Congressional Review Act, right? That if an agency did not submit that required report, that the rule itself would be invalid, it never issued, it never became law.
I think that is what happens under the Congressional Review Act.
If the report never, if the report is never sent, then the rule is issued. I don't understand it to be the government's position, but maybe it would be, Your Honor. If this court has no further questions.
Anything else, Judge Rao, Judge Millett? No, okay.
No.
Ms. Flynn, Mr. Byron, thank you very much for your arguments. The case is submitted.
Thank you, Your Honor.
Judges, I will call the second case as soon as the attorneys make their way to the conference room.
Okay.
That's an argument, huh? We appreciate it. Thank you for helping us. I'm sorry your work. Good morning.
Case number 21-1166, Independent Power Producers of New York, Inc., petitioner versus Federal Energy Regulatory Commission. Mr. Hughes for the petitioner, Mr. Ediger for the respondent.
Good morning, Your Honor. And may it please the court, Paul Hughes for petitioner Independent Power Producers of New York. This case reduces to a straightforward question. As part of its rate making, every 4 years, the New York Independent System Operator has to make a predictive judgment as to the anticipated economic life of a new power plant that would be built to meet increased demand. The issue here is whether the system operator reasonably exercises judgment to use a 17-year amortization period. In rejecting the system operator's proposed rate, FERC erred twice. First, FERC answered the wrong question. The issue should have been whether the system operator's choice was a reasonable one. Instead, FERC viewed its task as weighing two competing options and choosing the one it preferred. That mistakes FERC's role in a Section 205 proceeding. Second, the system operator's choice was—
Are you talking about as to that sort of balancing between options? Are you talking about the commission decision itself or its brief here?
Well, I think it's the commission decision itself, Your Honor, but its brief, I think, elaborates and makes clear what the commission did.
Where in the commission decision itself do you see them saying we just balance these things and pick whichever one we like best?
Well, Your Honor, in the commission's decision, there's no finding that the proposal that was selected or advanced in the proposed rate filing by the system operator was unjust and unreasonable.
No, I know that those words aren't there. I'm just asking where you think that I'm looking for the signal of the mode of analysis that you reference. I understand what you're referring to from their brief. I just want to understand where you think they were similarly, apart from not having used those particular words in their determination, where you think they were misapprehending, where you can point to evidence in their decision they misapprehended their role.
In paragraph 161, Your Honor, I think the mode of analysis that FERC offers here is that it considers essentially from first principles what it is that it believes the appropriate result should be, applying.
Well, it begins by saying NYISO has failed to demonstrate that this proposal is consistent with its services tariff requirement. That's exactly what it's supposed to do, right?
Well,
that's a you don't dispute that that's the type of analysis.
Your Honor, I think what's missing from here is any determination as to what the scope of reasonable rate making would be, and then any explanation as to why what was selected by the system operator was unreasonable against the backdrop. I think the closest that FERC gets is in paragraph 161, where it suggests that a rate as selected with 17 years could quote unquote be unnecessarily high. But I don't think that their suggestion that this rate could be unnecessarily high is the same as a finding that it is an unjust and unreasonable.
But what about, do you have a similar argument with respect to the statement that they failed to demonstrate that NYISO, who does have the burden of proof here to demonstrate just and reasonableness, failed to demonstrate that this proposal is consistent with its services tariff requirement to assess costs of new facilities, power facilities?
Yes, Your Honor, and I think exactly from what you're saying,
that's distinct from the may result in high costs. That's a distinct explanation for what NYISO failed to do.
Well, Your Honor, I think what FERC understands that to be is an argument that it's a suggestion that the system operator didn't meet its burden of demonstrating. And I don't think that analysis gets FERC where it needs to be for this reason. I agree that if there were a situation where a utility just offered a rate without any reasoned analysis underlying it as to the basis for how it arrived at that rate determination and submitted it with, again, no analysis, the commission would be justified in those circumstances in saying, because there was no explanation behind it, there was a failure to meet a burden. And in that gap, the sort of balancing and weighing exercise that FERC describes in its brief would be appropriate. But that's not what occurred in this case. At Joint Appendix pages 51 to 54, there are pages of analysis that incorporates other underlying reports and analysis, all of which that show that the system operator engaged in reasonable analysis. So I don't think it's a situation which you can say they failed to meet their burden of demonstrating the reasoning behind the reasonableness finding. And I think there's a very important legal and policy argument as to why FERC cannot so lightly find that there was a failure to meet a burden and substitute its judgment. And this is a point of agreement that we have with FERC. So at Joint Appendix page 1110, note 203, FERC cites and quotes the City of Bethany case for the underlying governing framework here. And this is what FERC says in that footnote. Quote, the commission's authority under section 205 of the Federal Power Act is, and then citing this court's precedent, quote, limited to an inquiry into whether the rates proposed by utility are reasonable and not to extend to determining whether a proposed rate schedule is more or less reasonable than alternative rate designs. Now, if FERC could just add sort of pro forma language saying that there was a failure to meet a burden, and then that was a basis by which FERC could then substitute its judgment and engage in the balancing and weighing exercise it describes in its brief, that would really negate the flexibility that section 205 provides to the utility to make a reasoned determination of an appropriate rate within the range of reasonableness. So to step back for a moment, to answer the court's question, I think it's appropriate for FERC to engage in the sort of weighing and balancing exercise that is described and undertook here if it does one of two things. If it makes a clear finding that what the utility has done is unreasonable, we don't think that they've done that here. Or second, if they were to find that the utility has failed to give any reasoned explanation or analysis to support its proposal, and in that lack of reasoning or explanation, there would be potentially a gap for the commission to fill. But neither of those things happened here. Instead, the commission went straight into weighing what it viewed as the 17 to 20 year, and then making, based on its own separate predictive judgment, what it thought the appropriate rate structure would be. So, Your Honor, we think that on that ground alone is a basis for this court to set aside what FERC has done. But I'd be happy to move to our second argument, which is even setting aside that failure in process of the commission. I think just substantively what the commission did here is not supportable. And that's because the system operator's exercise of its predictive judgment was eminently reasonable in this case. And where I begin with is the reason it's reasonable is how the text of the Climate Act works, its text, the manifest legislative history behind it, and as well as how it's been interpreted by agencies in New York State subsequently. Now, I recognize FERC has offered what I view as two counter arguments that I'd like to talk about. The one is the view that the target date may at some point be modified, and the second, the assertion that there could be some sort of alternative fuels that could be switched, such that power units that are built could switch to alternative fuels. So I certainly would like to get to FERC's two counter arguments, but to set the table first is the Climate Act has a manifest intent and purpose, and that is that there will be no fossil fuel generated power beginning in 2040. The text, this is section 66P2, I think is quite clear in establishing this mandate. And that says the Public Service Commission, quote unquote, shall establish a program to require that by the year 2040, the statewide electrical system will be zero emissions. And at the time the Climate Act was enacted, it was universally agreed upon that the purpose of this law, the reason the legislature enacted it, the governor proposed it, was in order to eliminate fossil generated electricity beginning in 2040. We've pointed to the governor's memorandum that summarizes the purpose and intent behind this bill, the remarks the governor made at the time of signing. All of the legislative history is in accord with it. That's the purpose of this act. And further, that's how a New York agency has continued to interpret the act since it was enacted. So as we pointed in our brief, the New York Department of Environmental Conservation has denied multiple permits, one to Astoria, another to Dance Camera, on the view, and they say, quote unquote, the statutory requirement that all electricity in the state be emission free by 2040. That is how the New York Department of Environmental Conservation understands and presently applies the statute. So that's the basis on which the system operator determined that there would be no natural gas generation for electricity beginning in 2040. And that was a reasonable determination in our view in the proposed rate.
Mr. Hughes, even if FERC's reasoning in rejecting the 17-year amortization period isn't maybe a model of clarity, isn't there enough in the record to support its decision? Couldn't FERC rely on its expertise to conclude that it was very unlikely that gas-fueled power plants would need to continue to be in effect in 2040 because of reliability issues, which the Climate Act specifically recognizes?
So thank you, Your Honor. I think the answer is just no. That was not something that was within FERC's ability to do. And the background legal principle, again, that FERC agrees with here is when the agency has to make a predictive judgment about what is going to occur in the future. And part of that predictive judgment is what the state of the law will be. There's a recognition that what the law is going to look like in 2040 is something that is nobody can predict with certainty. And so FERC has established a framework to assess that in order to minimize speculation in the current day. And that framework is they agree, and they point to a New York operator case in 2017. What they say is you apply the existing affirmative mandates and you do not guess whether, quote unquote, regulators will act at some point in the future.
I know, but this is a case, I'm sorry, tell me if I'm interrupting you, Judge Rao, but this is a case where the statute itself says more is yet to come, that these regulations have to be issued by the commission, and that there's sort of, protections in case, this looks like it's not going to work. And so we may need to adjust things as we go along. If it's not going to, we got to make sure whatever we do that we're providing safe, reliable power. So the current state of this law has embedded in it these contingencies. And you have, am I right? The commission opposed your position in this case, the one that's supposed to issue those regulations. You can correct my little fact if I'm wrong on that, but regardless, the statute itself has it embedded in there that yet, more is yet to be determined, and things, there's a chance things may shift. Then why aren't we in the land that Judge Rao was referring to, of where FERC's predictive judgment is appropriate?
So a few things, and Your Honor, I would like to come back to what the Public Service Commission said in this proceeding, because the basis that they opposed was on fuel switching, not that there would be a change in target. And I think that is an important distinction. I'd like to explain the problems with fuel switching, but that's a bit of a sideline. So let me come back to that in a moment, if I may. To answer your question directly, is what FERC law requires of the system operator, and this is what the system operator said at Joint Appendix 52, is we apply the law as it is currently, what it currently mandates, recognizing that there are always future acts in any statute. Any statute can be repealed by the legislature, modified by the legislature, and often there can be changes or exceptions that are later granted. The court is quite right to say that there is a recognition that future acts could be taken. But the distinction that FERC law draws, that FERC endorses in this case, but just was improperly applied, is this. The question is, what is the affirmative obligation as we stand here today? We don't guess at what affirmative actions we could hypothesize might happen in the future, but we don't know.
Sure, but to just be clear about what I'm asking, this doesn't feel like, well, maybe next year's legislator will repeal the law. This doesn't feel like that type of speculation at all, or who knows what a legislature 10 years from now do. They might throw the whole thing out. That's not what was going on here. They the best defense of their decision, and speaking for years, they pick up the statute and they go, this statute itself says the path forward is yet to be determined with any detail. And we have this goal in 2040, but we have this simultaneous goal of whatever you do, reliability of power must be preserved. And so we have two goals that could themselves be in tension, and a statute that itself says the path is yet to be determined. So we're not talking about who's going to repeal things in the future, whole new agencies coming in. We're looking at the current obligations under this statute. That feels different to me. Tell me why I'm wrong about that.
Well, because the current obligation under the statute is the shutdown by 2040, and let me explain that. I think FERC's position is deeply disrespectful of New York state law, because, as I said a moment ago, the legislature and the governor have plainly said that the purpose of developing this law is a shut off of natural gas by 2040, and this is what, in legally binding documents, the New York Department of Environmental Conservation is saying the state of the law is today. I quote again, this is at the Astoria decision at page 11, quote unquote, the statutory requirement that all electricity in the state be emission-free by 2040. That is the state of the law as a New York agency currently understands it and is making binding determinations as to its permitting process.
Sorry, is that agency, but if it's not in the statute itself, and the statute itself textually has more, at least could be read as having more, less certainty about that goal. If the statute itself, are you saying that there's case precedent from FERC that it ignored that says, well, as long as you've got an agency, an expert agency talking about its view, it's bound by that as well?
Your Honor, the case precedent that we rely on, this is what FERC says, and this is in the New York Independent System Operator Order from 2017 at paragraph 61. And FERC directs that we do not guess whether, quote unquote, regulators will act at some point in the future. And when we apply that to this statute.
But here they don't have to guess. The statute is clear that regulators will act in the future.
And what we know,
Your Honor, there's no guessing about that. It's just.
My apologies. Right? No, my apologies. Sorry, Your Honor.
It's harder on Zoom. Go ahead.
Again, I apologize. We don't guess because 66P2, Your Honor, is written in mandatory terms. That is, what we know is obligatory is the commission shall establish a program, and the result of that program will be a shutdown by 2040. Now, the language in the statute that FERC prefers says that separately, FERC or the commission may at some point make a future finding to adjust that target date. That is the thing that we do not know is going to happen. The status quo as it exists today is the 2040 shutdown. And we know that because that's the one provision of the statutory text that is affirmative and mandatory, that creates the mandatory obligation. We know that because that's what the governor and the legislature said that they intended to do at the time they enacted this. And we know that because that is what the state agency who has to make decisions about clean air permits is understanding the law today to mean, and that is how it's getting applied. That doesn't rule out the possibility that the Public Service Commission could take some future action to change that, but that's precisely where the FERC law comes in, as we don't make guesses as to if, and what FERC speculation is that although the governor and the legislature and the agencies are saying shut down by 2040, FERC's essential point is that at some point, New York is going to realize that their target date of 2040 is a bad idea because it's going to lead to reliability problems, and they're going to retreat from what it is that New York has affirmatively said they're going to do. Our point is, that's a guess. Maybe New York will effectuate the law as it currently exists and as the agencies are currently applying. And it's disrespectful of FERC to suggest that New York is not going to, in fact, be able to implement and apply the law as currently written, and will have to write an exception that's contrary to what the governor and the legislature said that they were doing in enacting this law. That's where the future speculation comes in. And that's where FERC precedent says, in order to minimize the effect of speculation on these predictive judgments, we apply the affirmative mandatory obligations, which is the 2040, and we don't take into account the Future Act, which would be a moving of the target date by either the legislature or the commission. And I think that's the key distinction that we're making, is between what is affirmatively required today versus what are actions that could be taken in the future that could move that right now we're guessing at based on reliability and other concerns FERC says might happen, but we just simply don't know. And the kind of wrap up of that point is what FERC has said in this law is, to the extent that there's a change in the future, something that we don't know, but say there's a change of the 2040 date, there's a ready-made solution for that, which is the demand curve is reset every 4 years. So today, when we do the 4-year demand curve, we use the affirmative obligations as they exist. If, as FERC is speculating, that there is some subsequent action taken by the commission that is an affirmative act that changes that, then in the next demand curve, that will be taken into account. But we don't guess today that what might happen someday down the road.
All right.
Sorry.
Good. Did you have something else you wanted to cover?
I was just going to talk briefly about the alternative fuel, the fuel switching issue, is the issue that the Public Service Commission mentioned. If I may, I know I'm over my time.
Just do it in a minute, please.
Thank you, Your Honor. There are really 3 problems, and I'll touch on them briefly about the fuel switching.
That is all 3 in 1 minute.
Yes, Your Honor. The first is that a Chenery problem, the fuel switching argument was just not made below. The second, the idea that there would be fuel switching in 2040 to hydrogen or renewable natural gas simply doesn't work on this record, because at J514, my client, citing record evidence, explained that this would be massively costly and would significantly increase the cost basis of the project, requiring very different kind of demand curve. At the very least, FERC would have had to have responded to that substantial rebuttal. They didn't, so that's not argument they can rely upon. And the third is this argument, I would just call it speculation on stilts. It's both legal speculation that there will even be fuel switching allowed. That would require some affirmative act by the commission that's not yet happened. And second, it's technologically speculative because it's unclear that there's going to be grid level hydrogen or renewable natural gas that will be available.
All right.
The Astoria decision says that, page 12.
All right, thank you. We'll hear from FERC. Yeah. Mr. Ettinger.
Good morning, and may it please the court. I'm Scott Ettinger for the Federal Energy Regulatory Commission, and thank you for hearing this case today. I'd like to go straight to the question of the procedural question about the just and reasonableness of the proposal to use the 17-year amortization period. And as we discuss in the brief, it is clear that the commission in this case, looking at paragraph 19 of the commission's order, it is clear that the commission made a finding, found that the 17-year amortization period is not just and reasonable. There are tons of myriad issues in this case that the commission accepted without discussing, and it singled out this particular issue, and it found all those issues to be just and reasonable, as it said explicitly in paragraph 19. And then the commission explicitly singles out the amortization period and addresses it separately. I would submit that the only interpretation of that is that the commission found it to be unjust and unreasonable. In addition, the paragraph 161 that analyzes the amortization period found the 17-year period to be inconsistent with the tariff. And I would submit that there's no, that necessarily means that the commission found it to be unjust and unreasonable. I would like to I would like to also address the, in the petitioner's brief in this case, what the commission, when I tried to explain what the commission did in this case, this court might get the wrong impression from what the record looked like from reading the petitioner's brief. There is no discussion of the market monitor's position. There's no discussion of the consumer stakeholders' position. There's no discussion of the New York Commission's position in this case.
What do they need to focus on other than the commission's decision? That's what's before us is the commission's decision.
Absolutely.
And the petitioners focused their challenge on the commission's decision.
Correct.
So
but
what's wrong with that?
What's wrong with that is that it ignores the record evidence that the commission relied on here. What I'm trying to suggest, Your Honor, is that the record looks very different than what was suggested. And there is a record that involves comments from the market monitor, from the New York Commission. That's what the commission relied on when it made the determination that the 17-year period is not just and reasonable.
And the commission, oh, sorry, go ahead, Judge.
Let me just give you one example. I mean, so the commission says, look, the state might suspend the zero emission requirement. That's one of the things FERC says. So what in the record supports that?
The excuse me, in paragraph 61, the commission explicitly relies on the comments of the market monitor. And for that, Your Honor, the comments are at the JA 954. And in addition, the comments of the—
Not all their comments relies on one comment.
Yeah, I mean—
One comment, relies on one comment.
It relies—
That the 17-year amortization period fails to consider that the statute does not require power generators to retire. That's the only thing it references.
That is correct. I would add to that, Your Honor, that the comments of the consumer stakeholders, which includes the New York Commission here, explicitly stated that they supported the comments of the market monitor. And that's—
Does FERC reference that? I mean, you're complaining that they haven't referenced that record information. Where did FERC reference that?
The commission discussed the comments of the market monitor.
Yeah, where did the commission? I get they've got not the comments. And if there's another one that I'm relevant to the issue before us, to be clear, if there's another one, I read to you the one reference that they have. I don't see them referencing the views of the commission. Did I miss that on this issue?
They don't explicitly, but they reference the comments in paragraph 157. This is at JA 1121. And there, the consumer stakeholders, which includes the New York Commission, stated—
That's just summarizing everybody's arguments. That's not them embracing it. That's not part. That's just right. That's not part of the commission determination.
But that is the determination. In paragraph—
No, actually, no. That's labeled arguments, and then there's on page JA 1123 commission determination.
But what I mean—
we're reviewing the commission determination. We're not fly-specking how well it recorded or reiterated what other people were arguing. And it's in its determination. I just want to be crystal clear, unless I'm missing something. It doesn't reference the commission's view. It references one point made by the MMU, which is that the statute on its face does not require power generators to retire. Is there more that I'm missing where they expressly referenced these other arguments?
There are no other
evidence.
I'm sorry, Your Honor.
No, I said arguments rather than evidence.
There are no other explicit references, but the entire pleading of the market monitor supports this point, and I would submit
it very well what may, but the commission didn't embrace the entire pleading of the market monitor.
It may not have explicitly, but the finding is that
where's your language that it's implicitly embraced the entire finding as opposed to the one finding that it, as MMU notes?
The entire filing supports the proposition that the New York Act does not require the fossil fuel generation today to retire in 2040. And that is exactly what the commission finds in paragraph 161.
I agree with that. Right. Okay.
And so I think respectfully, Your Honor, I don't think there's any other way to read that paragraph and what the commission is relying on. I would also.
Where do they, if these fossil fuel resources that they reference are going to stay in operation after 2040, I think you explained in your brief that they would have to engage in retrofitting or other substantial technological changes, correct?
That is one possibility, but that's not the only possibility. In the footnote, in footnote 255, the commission quotes the language of the New York Act, which there's a couple aspects of the act that I'd like to point out. First, the New York Commission, which hasn't issued regulations yet. So I would agree with the point that the precedent relied on by the power producers simply doesn't apply here, and we're actually consistent with that precedent because we don't have a clear environmental measure at stake here that the commission should rely on. But what I was going to point out is that the language in that footnote both tells the New York Commission that it must design the program, which it has yet to do, taking into account reliability concerns. And in addition, the further subsection of the Act, subsection 4, talks about how modifications can be made by the New York Commission.
Sure, and that's what I was asking you about, right?
Yes.
So modifications that fossil fuel.
Yes.
Fossil fuel producers would have to undertake, right?
That is explicitly contemplated in the Act.
And then I assume modifications cost money.
They do, and
maybe a lot of money.
But that's nothing.
It all seems like a lot of money to me. These numbers, anyhow.
Fair enough.
Right? It costs money, right?
That's right.
Where did FERC factor? If that's what FERC was relying on, where did they factor those extra costs into determining? I mean, they wanted to take the existing, you guys have a long phrase for it, but I would just say the existing power plant measure that you're using to calculate the rate here, the localized embedded, whatever all your words are on that. They just did that as an unmodified power plant. And they said, and they didn't disagree with that, but yet that can't be right. If they're right, that if what FERC is basing its decision on is the capacity, amortization has to reflect the capacity of these plants to make significant changes to their technology to be in compliance with and still be there in 2040. And they could still be there in 2040 if they make these significant changes, or at least that's one option that FERC discerned. They would have to make these significant changes, but those significant changes would mean that the baseline that was used, the baseline plant cost that was used, was all wrong too. And so FERC can't have it both ways.
Well, I would submit, Your Honor.
Where did it grapple with the costs, those increased costs, and their effect on rates?
And again, the paragraph 161 is in front of the court. It doesn't in that paragraph, but again, it cited the market monitor, and the market monitor discusses this. And
oh, but again, I know you want the reference to the market monitor to be everything the market monitor says, but I think they've said specifically what part of the market monitor they're relying on, that there's no required shutdown. Further, and now they're no longer talking about MMU. The statute recognizes that requirements can be modified to allow them to remain in service. And that would include, as you argued in your brief, all these retrofitting. But the cost of all that has been never factored in by FERC. How could that be sensible?
Well, I would respond to that, Your Honor, by saying that phenomenon is nothing new. The consumer stakeholders point this out in their brief, that the idea, it is well established, they say, that configurations will change. They say this at page 19 of their comments. This is at JA 753. We just don't know at this point, and in the future.
Well, if FERC based its position on the notion that fossil fuel operators can retrofit, modify, in substantial ways that would keep them relevant after 2040, to determine that this rate was unjust and unreasonable, didn't it have to know how much it would cost for those plants to do that? Because it could well be that that retrofitting would require an even higher rate than what is proposed, what it says may result from this amortization schedule.
And again, Your Honor, I would suggest that will be settled. That can be settled in the future. This is.
Well, usually when FERC says that will be settled in the future, it's because they refuse to engage in any speculation at the time. To say and that's the other side's argument, right? Look, right now, take it as it is. This is done on a regular, repeated basis, and if changes happen, then we'll factor it in. But that's not what FERC did.
But again, Your Honor, the law doesn't require the retirements in the first instance. And if they are permitted, I point out as well that if they are permitted to continue operation, as the market monitor suggested, to meet reliability.
Well, the law requires certain targets be met, correct?
It does. It requires the commission.
Okay.
I'm sorry, I didn't mean to enter. It requires the commission to adopt a program to meet those requirements with reliability concerns in mind.
But it still has to meet the zero emissions requirement. The commission doesn't have the authority to go, we don't like this zero emission requirement. It has to establish targets that will get there and satisfy reliability.
I'm not sure I can agree with that, Your Honor. I know that the law it requires the establishment of a program to meet the targets that Your Honor is referring to, but it is with the reliability concerns in mind.
With reliability concerns in mind, right?
Yes. Exactly, and we've got evidence in this record, and again, the market monitor cited 3 studies suggesting that dispatch.
But FERC didn't cite any of those studies, so it doesn't.
It did not. But it cited the market monitor, and it fully supports. The commission's finding that the law doesn't require these facilities to retire.
Anything else? Okay. Thank you. Mr. Hughes, you are out of time, but you can have a minute.
Thank you, Your Honor, and I appreciate the court's indulgence, but I think the court well understands the issues, and I wish not to repeat myself, so I'd be happy to answer any questions the court may have.
Hearing none? Whoops. No? Okay. Hearing none, the case is submitted. Thank you both.
This honorable court is now adjourned until Thursday, April 21st at 9:30 a.m.